That is not a ground, not to us. Yes, next.
Your Lordship, may I have your leave to mention a matter, Your Lordship. This is a relaxation of bail condition.
What do
Your
you want?
Lordship.
Inclusion? Hand over
No,
the slip.
no, Lordship. Your Lordship, for upgradation. Your Lordship, the matter was
No.
listed for at top.
Next.
Under compelling circumstances, mention one matter, Lordship, on item number 1053 and 1054 in today's list, Lordship. That matter, Lordship, one is revision application and another is, Lordship, bail application. Regarding the statutory bail point, earlier, Lordship, heard this matter, Lordship, before, Lordship, vacation, Lordship. Kindly fix any date, Lordship. The person 6 years in custody, Lordship.
Person?
The petitioner in custody for 6 years, Lordship. Kindly fix any date.
Yes, custody. 1053
and 1054. One is revisional application and another is bail application.
6 years in custody. To be mentioned. Tomorrow to be mentioned.
Get to Lordship.
Notify your other side.
Your Lordship.
105.
Your Lordship.
My client was suffering for 3 years and not 7 months.
3 years, 7 months, and 6 years. There's a difference.
May I be
Your
permitted to
Lordship.
mention? My lord, in this matter, item number 771 is in custody for near 6 years. On Thursday, I had mentioned, Lordship accepted that I notified the state, but this is not in upgraded section.
But what did we say?
Item number 771.
What did we say on Thursday?
Thursday, I had mentioned this.
To be mentioned. Kore dao to.
Thursday on the same ground. He was in 6 years.
To be mentioned. Kore dao.
Your Lordship, the matter is pending since August, and Lordship, the matter was been listed at the top of the relaxation of the list,
Very
Lordship.
well. Next.
That relaxation matter, my lord, where Mr. Nondi was.
Mr. Chatterjee,
Off and
before the vacation last week, we did not take up those matters.
Lord.
Now we'll start taking up those matters. In fact, today itself, it's a relaxation day. So let us see.
Very well.
Yes.
Deeply.
আজ কি তো রিল্যাক্সেশন হবে 3টে থেকে
Item number 1.
I for the petition.
correction.
May I submit one thing? A similar type of case, Lordship granted interim bail in another.
Which one?
What is the order?
Item number 1.
Item number 1.
Whatever.
A similar type of
For correction,
another case, Lordship granted interim bail.
You have brought it for correction. What is
We have rejected your application. Then what are you trying to show us now? That's
for correction?
let the cause title of the order dated December 16, 2024 be corrected by substituting CRM bracket NDPS 1538 of 2024 by substituting ki bollam 2024 in the place and stead of CRM DB 1538 of. So let this correction be incorporated in the order.
Lordship, I am appearing for the petitioner, Lordship.
Yes. Correction.
Yes, Your Lordship.
What correction?
The PS case number, Lordship, police station case number, it's
Yes. What is the
19 of
correct?
2024, Lordship.
Correct
Police-
number is?
Correct number is 19 of 2024, Lordship.
I see. Date is all right.
Yes, Your Lordship.
Let the cause title of the order dated December 23, 2024 be corrected by substituting the police station case number as 19 of 2024
Yes, sir.
instead of 190 of 20. Well, 0 extra পড়ে গেছে আর কি। Yeah. Let this correction be incorporated in the.
Well, at item 3, I'm for the petitioner. Well, at your
Lordship, I was supposed to submit a report, Lordship. I seek a week's time to file
comprehensive.
comprehensive report, Lordship. I seek a
Well,
week's time.
Interim bill is continuing.
Continuing, my lord, your lordship has once extended it, so
No
well,
problem.
Interim bill up to 30.
whether my learned friend will be able to do it or your lordship can keep it. There's
Lordship, I
much
seek a week's
urgency
time.
is not there.
Report.
Lordship, I
My lord can take it up in February also.
Comprehensive report, Lordship, it is awaiting. Lordship, I will file within a
Uh,
week.
The learned advocate for CBI seeks a week's time to file a comprehensive report. Stop. Such time is granted. Stop. The report shall also indicate whether or not the petitioner has been adhering to the conditions of interim bail.
Complying.
Stop. Paragraph lists this matter once again on it.
My lord, one indulgence, my lord. I am just handing up a convenience compilation to your lordships with a copy to my learned friend. My lord, your lordship will recollect there were, my lord, transfer petitions. My lord, this also relates to post-poll violence. My lord, all the post-poll violence matters all over West Bengal, my lord. One transfer petition was preferred before the Supreme Court to transfer everything out of West Bengal. Now, my lord, initially, my lord, the Supreme Court on 14th of February 2024 had issued notice and stayed all the trials, including this case. Now, my lord, ultimately, my lord, on 20th of September, my lord, since the pleadings were defective and, my lord, in fact, aspersions were made against the learned courts, my lord, the Supreme Court gave an opportunity and the central government, my lord, withdrew the transfer petition with a liberty to file afresh. Now, my lord, along with the transfer petition, my lord, a bail application was tagged. That bail application, while, my lord, dismissing the transfer petition as withdrawn, the Supreme Court said that we'll take it up after some time. Now, my lord, that bail application, which was before the Supreme Court, tagged with the transfer petition.
Bail application of this petitioner?
No, my lord. The a bail application of, my lord, Nodia, of a particular case in Nodia where this court had, my lord, Justice Bakchi's division bench had rejected bail of 4 persons on the ground that there were specific roles played by them. That SLP, after some time, was decided, and in that matter also, my lord, bail was granted to the accused on the ground primarily of delay in trial. Lord, what I have done in this compilation is I have put all the orders of the, my lord, transfer petition and also the order granting bail to co-accused, not in this case, but in the, my lord, post-poll, another post-poll case, which was tagged with the transfer petition.
File it. List this matter. This is a miscellaneous matter.
Yes.
Miscellaneous. এই miscellaneous
নদিয়ার কেসের অর্ডারটাও দিয়ে দিয়েছি।
আজকে পক্সো
জয়মাল্যদা
কালকে
রিজেক্ট
NDPA
করেছিল, সেই অর্ডারটাও দিয়ে দিয়েছি।
ফ্রাইডে কি ছিল?
সুপ্রিম কোর্ট
ফ্রাইডে
দিয়েছে, সেটা
miscellaneous ছিল।
প্যাজিনেট করে দিয়েছিস তো?
তাহলে পরশু মিসলেনিয়াস, তো বুধবার আবার হবে তাহলে নেক্সট মানডে মিসলেনিয়াস। ঠিকই আছে, মানডে, নেক্সট মানডে।
Next month.
ডেটটা দিয়ে দাও।
But I've given a copy to my learned friend.
Compilation of orders
Orders of the Supreme Court and this court.
orders of the Honorable Supreme Court and of this court, of the Honorable Supreme Court and of this court, filed on behalf of the petitioner, be kept with the records.
Lordships.
Item number 4.
The petitioner number 1 and 2 are in custody for 7 years, 4 months. Occurrence is of the 14th July 2017.
Madam,
My lord,
And-
my lord, now kindly, my lord, this petitioner, along with the other co-accused, my lord, total 5 times, my lord, this Honorable High Court has rejected their bail. My lord, it was lastly rejected on 30th of April 2024. My lord, that order is annexed with your lordship's petition. My lord, page 15. My lord, kindly comes to that order once before I go to the merit of the case.
And my lord, since October, there is
Page
no
15.
court.
My lord, the paragraph 3. Oh, my lord.
So you assured to complete within 1 year.
Malad, within 1 year. Now, Malad, after this order was passed, Malad, 7 witnesses more has been examined. Total, there were 18 witnesses, out of which 15 has already been examined. 3 more are left. Now, Malad, if we consider this 1 year, Malad, this is 30th of April 2024. That means, Malad, we have to complete the trial within 30th of April 2025. So, Malad, we still have 4 months, approximately
So
4.
you have a presiding officer.
Malad, that information I do not have.
I
I've
think
just
Mr. Rai is saying there is no court is vacant.
Since October, court is
but
vacant.
some
And my lord, your lordship will find, my lord, though my lord, the charge sheet witness number 15 and 16 were scheduled to be examined on my lord, the 4th February 2025. My lord, this is the order. My lord.
Mr. Roy, we'll call for a report. and
Malad
we
may
do-
call for a report. Malad, as of now, Malad, the instruction I have got, 15 has already been examined.
petitioner,
My lord, the 10 witnesses have examined to my
Peti-
my lord, instruction.
That's why we are looking for.
since you can't agree on the facts, we have to, the
And
petitioners
15 witnesses can't be examined. because
complain
witnesses are
that they are in custody for more than
examined by
7 years.
February.
You dictate the order. Dictate the order.
I'm sorry.
For more than 7 years. Stop. On April 30, 2024, while rejecting their bail prayer, a coordinate bench had, on the basis of assurance meted out by the state that the trial will be completed within 1 year, had directed the trial court to conduct the trial with utmost expedition and conclude the same within 1 year from the next date fixed for recording evidence. Stop. The petitioners say that still the trial has not concluded. Stop. The court is lying vacant from October 2024. Paragraph, let the state file a report regarding the status of the trial. Stop. The report shall indicate, inter alia, how many more witnesses the state proposes to examine and an approximate time frame within which the state expects the trial to conclude.
Malad, great.
And my lord, how many
This the
witnesses
matter.
they have examined, my lord?
Malad, I'll get
How
the
many
entire
will appear
details.
from record only?
Yes,
এটা কি miscellaneous, no?
Malad.
Can you do it on Wednesday, day after
Malad,
tomorrow?
Malad, it will be
Monday,
little.
Monday.
Malad, next Monday. Grateful, Malad.
Next Monday. Monday, শোনো, Monday under the appropriate heading amongst the first 5 items.
Malad.
হ্যাঁ, তাই করে দিও। Appropriate heading amongst the first 5 items.
Lord, I'm appearing. My lord, I am appearing on behalf of the petitioner. Allegations are under
Not pressing, ma'am.
Not press করে দাও। হ্যাঁ?
On the last occasion, I have drawn your lordship attention to the order passed by your lordship on 3rd of December 2024.
Yes, Mr. Nandi. 24 hours issue, that production. That's Article 22. No. Article
20, Article 20, Clause 2.
20, Clause 2.
You are paying for bail for which petitioner? Name? Professor.
Professor. He was the district inspector of schools.
He has granted bail.
Earlier.
Earlier.
Notes these dates. 19/4/24, it is at page 3882. 19/4/24. Gave the prayer for shown arrest, jail interrogation. The learned court allowed that same prayer.
Under which provision of law landed court allowed to show him arrested?
No, my lord. May I just? My lord will kindly come to page 3887 there.
3887.
Yes. The production warrant against
3887.
Yes. 3887. The production warrant against Chopesha Shodhar to appear on 24/4/24. The London magistrate passed that order. Now, my lord, kindly come to page 3892. On 24/4/24, this accused was not produced, and there was a direction upon Superintendent of Correctional Home to positively produce the accused on 2/5/24. Now, my lord, page 3899.
Yes.
That is on 2/5/24. He was produced and he was taken into custody in connection with this case.
He is saying under which provision of law here?
But he was never produced. He was never produced. A prayer to show him arrested was made. But for that, the magistrate directed, let the accused be produced. A production warrant was issued.
He was in correctional home in connection with
Another case.
So he has been produced before this.
He was produced before. Production warrant was issued. He was produced. On the next date, when the production warrant was issued, on the next date which was given, he was not produced.
So,
Then there was a direction to
so you are
produce.
saying when he was, this issue of 24 hours is not there because he was taken into custody in connection with this case
On 24,
only when he was produced,
when he was produced,
not before that.
not before that.
So there is no 24 hours
No,
lack.
no, no.
Mr. Balchuki.
He was produced on 2/5/24. That is the date because London magistrate didn't allow my applications.
Allow him to.
My lord.
Lord, 24th of April, 19th of April 2024, the petitioner was shown arrested. Then again, Lord, as per the order of the additional session.
What is the order sheet? Order sheet of 19/4/2024 that he has
Yes.
been shown.
So that, see that, under which provision of law, the learned additional
Without
session
production,
judge,
he cannot be shown arrested.
under which provision of,
He was not produced. A
No,
production
sir.
warrant was issued.
where,
That is what I
please,
was showing to your lordship.
please.
This, my lord, I have not
No,
been given.
I have not given, what do you mean by I have not given? On
This,
your prayer,
I am showing as per the case diary.
under which provision of law, the additional session judge allowed the prayer of the prosecution to show him
But
arrested?
he has not allowed. He has
Just a minute.
Allowed.
Allowed.
but a production warrant was issued.
Mr. Nundi, when we are saying something, we are saying so with some responsibility.
You have mistaken one thing. After process, he must be taken into custody in connection with that case. That's what
Absolutely,
not
Madam.
allowed.
Until unless
But-
he is
but you
produced,
see
I
that-
cannot take him into custody.
দেখাও তো দেখাও দেখাও দেখাও।
Therefore,
ওই দেখবো না কিছু না কি
স্যার এটা আমাকে তো দেননি। আমি তো আমার কেস
তোমার পেয়ারই তো হয়েছে
স্যার আমি তো আমার কেস ডায়েরির পাতা দেখাচ্ছি স্যার।
রিডিং
Underlined,
হ্যাঁ
allowed.
which provision of law the learned judge did it?
whether he is produced on 19/4/2020.
No.
But prayer for soon arrest is allowed. Just see one line.
He was not pursued. Next line, issue production warrant against the accused person on 24/4/24
That's the
for
continuation.
production of the said accused.
After being shown arrested.
That is the fault of the learned magistrate, my lord.
The fault of the learned magistrate is the fault of the constitution.
Yes. He is not taken into custody, but prayer for soon arrest. is
Because
allowed.
that is the reason on the next date which he was, that is on 24th, that day also he was not produced.
This is an illegal order. It's an
He is
illegal
not taken
order.
into custody. In spite of that, prayer for soon arrest is allowed. This is the point he is raising.
But that is not reflecting in that.
You want to take further instructions or shall we?
But that is an order sheet, my lord. What further
Correct.
instruction I will take? That is the fault of a
How long
learned
you are in
magistrate.
262 days.
And so far as the merits of the case, my lord,
And
It's
it's
a-
a civil matter.
no.
406.
No.
All right, blood. This speaks about illegal appointment of a teacher in charge in a school called Bhimpur Santal Girls High School, and the petitioner being the district.
This is not that Hatua, one of.
No. It's a absolutely different school altogether. My lord, this is
There is a technical defect.
there is a technical defect, my lord. I have no words regarding that. However, my lord, in this case, this is Bihar, Orissa, Bengal Baptist community. That they run a Christian missionary school.
Please
Now, in
remember
that school,
you
my
and
lord,
I, we are bound to follow the constitution.
Investigation complete.
no, my lord, investigation is going on.
What?
This
But
chopper,
why not?
Charge sheet not submitted.
Submitted.
my lord, while the investigation is going on,
That is
all the other accused persons are absconding. Now, my lord,
What?
this
The other,
they have filed a revisional application. They have not
One second.
cooperated with the
what
investigation.
is,
The present petitioner before your lordship, my lord, he himself rejected applications for appointment. Then again, on few days after, he again appointed those persons.
All right, very good.
what is the nature of charge in the other matter in which bail was granted to this petitioner?
I don't know.
That is regarding a particular school wherein he has given an illegal appointment.
Well, this is
Same
Yeah.
type of
No.
charge.
Here, my lord, there are at least I could get 30 persons.
regarding appointment.
And my lord,
therefore.
Then your lordship granted bail in the other case. This is the order passed by you.
my lord, there I have that order, my lord. This
Investigation complete.
my further investigation is going on. Other persons, they have filed a revisional application. They have procured a order of no coercive steps and they have not cooperated. At least
And
I
I-
have 50 odd persons who have been examined. They have given crores of rupees for appointment. This is a different case altogether. my lord. This is so far as that previous case, that is particular one school. Here, that was a particular one individual. Here, at least 30 persons are there who have paid money.
Whoever
Here,
the
at
persons who
least,
have paid
here at
money,
least 9 appointment has been rejected by this man, and those 9 appointments have been again reinstated by this present petitioner.
Where do
Those
you,
documents are there.
where do you reside?
what I recite, I will tell you.
Paschim Mednipur,
Paschim Mednipur.
police station Moyna. Where is the case pending?
No, this is
Yeah.
Shalboni police station.
Calgary.
Shalboni is now Jharkhand.
No, no, it's Paschim Medinipur.
Yeah.
The learned counsel for the petitioner has
True.
submitted that the petitioner has been falsely implicated in this case. Apart from this, there is serious illegality in showing arrest of the present petitioner on 19/4/2024 by the concerned judicial magistrate, since without producing him before the concerned judicial magistrate, the prayer for shown arrest has been allowed by him, which is totally illegal and unconstitutional. Stop. Para. Moreover, the investigation of the instant case is complete. He may be enlarged on bail on any condition. Stop. Para. The learned counsel for the state opposes the prayer for bail vehemently. According to him, the present petitioner is the kingpin of the.
This is one of the. My lord will
What-
kindly record my submission regarding
Yeah, but-
19th, which I have made. My lord, he was not.
Official record.
Well,
We have started to
I'm
record
good,
your
I'm good.
submission.
Very good.
Okay. So you have understood what is going to be. One of the kingpins of the one of the kingpins of the education scam, which occurred in which district?
Paschim Medinipur.
This is in Paschim Medinipur.
In the district of Paschim Medinipur. Stop. The learned counsel for the state has further submitted that there is no illegality in showing arrest of the present petitioner, since production warrant was issued on 19/4/2024, but on the subsequent date, the petitioner was not produced. Stop. On 2/4 or 2/5,
2/5/24.
on 2/5/24, when the
No, my lord, on 24/4/24, he was not produced. So there was a direction upon the superintendent of the correctional home to positively produce the same on 2/5. So
on
2/5 he was produced and
on
taken into custody.
2/5/2024, when the petitioner was produced before the concerned judicial magistrate, he was shown arrested and taken into custody in connection with the relevant case. Stop. In fact, there is no illegality committed by the learned judicial magistrate, and therefore the petitioner cannot be said to have been arrested illegally. Stop. Para. Further investigation is going on. If the present petitioner is enlarged on bail, the prosecution as well as the investigation may suffer a lot. Stop. Para. We have considered the materials on record. We find that investigation is complete and the documentary evidence relating to the alleged offences have already been collected by the concerned investigating agency. Stop. Moreover, we find that on 19/4/2024, there is a mistake on the part of the concerned judicial magistrate by allowing the prayer for shown arrest. Stop. Without without the magistrate being produced before him. Stop. However, as the investigation is complete, we are inclined to allow the prayer for bail of the petitioner on condition. Bole? Condition herein 50,000 টাকা, দুটো লোকাল সিওরিটি, দুটোই লোকাল সিওরিটি।
But instead of judicial magistrate, it will be additional session judge, first court, Paschim Midnapur. He is the court that passed the order.
Oh. So,
Whenever you last say judicial magistrate, it will be replaced by additional session judge, first court, Paschim
legal
Midnapur.
magistrate হবে না, ঠিক আছে, সব জায়গায়।
Paschim Midnapur.
50,000 টাকা হলো, ঠিক আছে, লোকাল সিওরিটি হলো, he shall not leave. Why he is residing now, right now?
কোথায়? আগে
Right now in jail.
হয় না?
Shall not
Yeah.
leave Moina PS jurisdiction excepting for the purpose
Moina PS.
and shall meet the OC Moina PS once in every week. And shall cooperate with the Ayog for further investigation of this case.
Grateful.
তবে কি হবে বলতো এখন?
ঘাটনা একসাথেই হবে। Eight and nine.
8 and 9. 8. I'm appearing for 8 only.
Lordship, in this case, initially the prosecution case was that CCTV facts is that a cricket match was going on, the fight at that ground. Initially, prosecution case was that there is a CCTV footage against me and 164 statement of two eyewitness. Now, this honorable court found that CCTV footage is hazy. So, discard the CCTV footage at page 9. At page 9, your lordship will find this honorable court peruse the CCTV footage.
My lord, to cut short the matter, my lord, he is standing on the same footing with the co-accused who has been granted bail by your lordship on the earlier occasion.
Where is that order?
My lord, that
Earlier, eta diye daun. Now, those 164 statements.
my lord, I'm making my submission with regard to item number 8.
Yes, we are only
Those
on it.
164 statement was there. Now, those witness in their deposition stated, we heard from others. Considering that, your lordship has been pleased to grant.
Issue. The petitioner claims parity, citing an order dated November 28, 2024, passed by this bench. In CRM DB 2944 of 2024, whereby a co-accused person, namely, Asif Hussain, was enlarged on bail. So the petitioner says that he stands on the same footing as that person. Paragraph, while opposing the prayer for bail, learned state counsel, in her usual fairness, does not dispute that the petitioner herein is similarly circumstanced as the aforesaid Asif Hussain. Paragraph, hence, on the ground of parity, we are inclined to allow the petitioner's prayer for bail next accordingly. Same conditions, Asif ke condition.
9 is also lordship same, another co-accused.
Who is for the state?
I'm for the state.
Same footing.
Same footing, only bamboo stick has been found from his custody.
Thus, same order.
Investigation complete.
Investigation complaint, trial going on. The witness 164 statement witness during trial stated we have
Same
heard.
order.
I have annexed the 164
Asif Hussain issue.
3 and 4. Grateful. CDM Lalbagh.
Grateful.
হ্যাঁ ওটাই আছে আছে
Mr. Maiti, you will keep us occupied till recess?
Yes, yes.
Other matters released till recess?
On the last occasion, my lord, your lordship kindly recapitulate the fact, my lord. I started my arguments, my lord. My lord, so far as the, my lord,
আমার চিন্তা জীবন বলবে আমার জেনুইনলি অসুবিধা হচ্ছে Yes, Mr. Pak.
on the last,
এখানে কি নোট আছে নাকি?
কোনটা ধরছি আগে?
Taking notes, no?
Yes.
We were.
I think.
Yes, yes.
Well, that matter where, my lord, the investigation was transferred by the Writ Court to the NIA, and then, my lord, on the ground that
Yes, yes, the bail was cancelled.
bail was not confirmed.
No, it was cancelled.
Interim.
It was cancelled.
No, not.
No, that's the version of the cohort.
My lord, perfectly, my
version.
learned friend is not perfectly right, my lord.
Interim bail.
The
which was not
interim,
confirmed
yes.
On his application.
Note নিচ্ছিলাম।
Interim
Anyway, you
statutory
continue.
My lord,
All of you filed short notes.
yes.
I will file today, my lord. I just had.
My lord, on the last occasion,
End
my
of the
lord,
hearing. Hearing will not conclude today.
no.
I have it.
Yes.
My lord, your lordship may be kind enough to, my lord, recapitulate the, my lord, facts, my lord, which I was arguing before lordship, my lord. My lord, the first one, apart from the merit, my lord, before coming into the merits of the case, my lord, I submit before your lordship, my lord, for your lordship's consideration, my lord. But 167 subsection 2 is a provision, my lord, of the Code of Criminal Procedure for the purpose of default, my lord, default bail means, my lord, for the purpose where, my lord, in a given case, my lord, where the, my lord, investigation is not completed and, my lord, charge sheet is filed on conclusion of such investigation before the court, my lord, under that circumstances, my lord, option is, my lord, one, my lord, to the investigating officer, either before completion of investigation, my lord, to pray for fine, and with sufficient reasons, my lord, the court can enlarge the, my lord, prayer for before expiry of the statutory period for granting bail, my lord. Court can consider it if it finds that, my lord, it cannot be done, but it can do it, my lord. But once, my lord, the court is satisfied.
One second, Mr. Maiti. Come at 2 o'clock, not now. Madam, and you come at 2 o'clock.
But, my lord, in a case, my lord, where, my lord, even the investigation is not completed and charge sheet is not filed within the statutory period, my lord, then the court has no other option but to grant the, my lord, bail, my lord, that is under the provisions of 167 subsection 2. My lord, that is a, my lord, simpliciter, my lord, the provisions, my lord, embodied in the law, my lord, to, my lord, afford opportunity to the, my lord, accused to have his, my lord, my lord, liberty to have the opportunity of bail. Now, my lord, whether question is, my lord, I was, my lord, making a submission, my lord, that whether in a given case, my lord, whether the provision taking recourse to provisions of section 167 subsection 2 simpliciter is a recourse to, my lord, 167 subsection 2, or, my lord, it is actuated by, my lord, perpetration of fraud, my lord. My lord, because, my lord, by keeping the 167 subsection 2 as a shield, my lord, by perpetrating fraud actuated by the state agency, my lord, for the purpose of facilitating bail to the accused persons, my lord, charge sheet was not filed. The lordships may be kind enough to ask me this question, why I am making this submission, my lord. Because of the reason, my lord, that the charge sheet was, my lord, investigation was completed and charge sheet was made ready on 4th. That is, my lord, on 4th. That is, my lord, 4th August 2023. It was signed by the investigating officer. that is, my lord, SDPO.
It was ready.
Charge sheet, my lord, investigation was concluded and charge sheet was made ready and was signed on, my lord, 4/8/2023.
But it was filed.
But, my lord, unfortunately, my lord, in a mysterious circumstances, my lord, this charge sheet was not filed on, my lord, 4th. On 5th, my lord, the, my lord, 167 subsection 2 provisions of the CRPC, my lord, was, my lord, bail was filed, my lord, to have the opportunity of statutory bail by the accused person. On 5th, my lord, the bail was granted under the provisions of 167 subsection 2 by the learned court below, before 2 p.m. And, my lord, thereafter, my lord, bail bond was, my lord, submitted within 4:30 on 5th. On the same day thereafter, my lord, that is, 5:20, my lord. These are very important, my lord. That's why, my lord, I am submitting on facts, my lord. 5:20, my lord, the charge sheet was filed by the police.
430. 520.
5:20, my lord, charge sheet was filed. Your lordships may be kind enough to, my lord, consider that, my lord, civil rules and criminal rules and orders. My lord, the criminal rules and orders, my lord, kindly consider. The criminal rules and orders, my lord, kindly have a chapter 2 of the general, my lord, code hours, my lord. Kindly have a look at, my lord. Yes. Rule 3.1, chapter 2, the ordinary codes of, these criminal rules and orders, my lord, I am quoting, my lord, from criminal rules and orders, my lord. That is, my lord, the ordinary hours of sitting for all courts shall be from 10:30 a.m. to 5:25 p.m. Indian Standard Time, with half an hour break in midday. In hot 2, my lord, clause 2, my lord, in hot weather, if the holding of morning courts be permitted by the High Court at any situation, courts of the said station may sit for 6 a.m. to 11 a.m. Note, in this sub-rule, hot weather means the period between the 15th March and 30th June. The exact date of being fixed by the Chief Judicial Magistrate in consultation with the district and session judge and the district magistrate. So, my lord, now, my lord, your lordships may be kind enough to, my lord, consider why I was submitting before lordships, my lord, with great emphasis that, my lord, a fraud has been practiced for the purpose of facilitating bail or statutory bail in favor of the accused persons by the state agency. In which manner, my lord, all the circumstances are there, my lord.
If the fraud was committed upon any court,
yes,
why should you file application for cancellation?
But I am coming to that. 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 So, my lord, that is, my lord, now 5:20. That question was posed by your lordships, my lord. I am coming to that. I will answer. So, my lord, 10:30 to, my lord, 5:00 p.m. So, beyond 5:00 p.m., my lord, what they have done, it is a camouflage of filing of charge sheet for the purpose of facilitating bail. What is the distance between the my lord, office of the, my lord, SDPO and the court, my lord? 180 meters. 180 meters is very important, my lord. What I am submitting, everything based on records and based on, my lord, facts, my lord. That no detailed investigation is also required, coupled by the circumstances under which, my lord, this was taken recourse to, my lord. So, my lord, 180 meters means, my lord, at least in walking distance, my lord, 2-3 minutes time or 4 minutes time maximum. So, my lord, bail was granted before recess. Bail bond was completed by 4:30, and thereafter, my lord, even they were in some doubt, took the informations, Everything has been done. There were 520, my lord, that was received. That was filed in 520 on 5th, my lord.
Charge sheet.
Charge sheet. It was signed, my lord. It will appear from the records, my lord, that charge sheet was signed on 4th August. And filed on, my lord, 5th August, after the accused persons were granted bail. Not only granted bail, they submitted the bail bond. Your lordships may be kind enough to, my lord, consider the aspect, my lord. Even if, my lord, charge sheet is filed before filing of the bail bond, the, my lord, the accused is not entitled to, my lord, get the privilege of, my lord, 167 subsection 2. But the police agency, my lord, state agency, was very much cautious. Lord, after the grant of bail, even the bail bond was submitted. Thereafter, charge sheet was filed beyond the court hours at 5:20, my lord. So, my lord, all to facilitate, my lord, the accused persons to be released on bail by filing bail bond. So, my lord, that was an interim bail. Now, my lord, so, my lord, my respectful submission should be, my lord, before your lord, in a given case, an order of granting bail under section 467 subsection 2 of the Code of Criminal Procedure appears to be deliberate attempt to bypass the object of the provisions by resorting to the fraudulent practice and committing a fraud on statute. Lord, fraud on statute means, my lord, the, my lord, statute is a, my lord, sealed. I am entitled to get bail. My lord, charge sheet has not been filed within time, so I am entitled to get bail. Then it is open to the court to crack the shell of fraud, which wraps the order of granting bail, interim bail, by piercing such a veil to find out the actual situation behind the order of granting bail, which have been obtained by playing fraud, not only upon the court granting bail, but also upon the statute itself.
What are you reading?
But this is my precise note.
Your note?
Yes.
Not some decision.
No, I will submit a decisions, my lord, later on, my lord. So from the well-established situation, coupled with the, my lord, all the circumstances, my lord, it is evident that opportunity of bail under the provision was not available to the accused as availability simpliciter, as is done, my lord, in case of, my lord, situations where, my lord, charge sheet could not be filed within 90 days or, my lord, somewhere, my lord, 60 days, my lord. Then, my lord, simpliciter case, that 167, provision of 167 subsection 2 is available. The provision was available to the accused as availability simpliciter, but the same has been obtained by a fraud played by the state agency so that the accused gets an opportunity to get bail under section 167 subsection 2. Now, your lordships were asking me a question, my lord, that why, my lord, my lord, the cancellation of bail was not paid for, my lord. Now, my lord, there are some list, my lord, list of dates, my lord.
You're ready for
Yes, definitely, my lord. Whenever your lordship is, my lord, pleased to ask any question, we are bound to answer all the questions. Because we are always duty bound. We are to assist your lordships. So, my lord, now the incident was happened on 1st May 2023. One person died, one person was injured. And, my lord, FIR was registered on 2nd May. And charge sheet was filed, my lord. The charge sheet was signed on, my lord, 4th August and filed on, my lord, 5th August at 4:20 p.m. Bail bond was submitted on 5/8/2023 after between 4:30. Prayer for cancellation of bail by the police. Yes. At that time, we did not take up the investigation, my lord. We did not take up the investigation. Now, what is the situation I was submitting, my lord? My lord, if your lordship is kind enough to permit me use this language, my lord, then I can, my lord, say that it's a case of a camouflage, my lord, situation. Camouflage, my lord, acting of the state police agency, my lord. Sapo mollo na latio bhanglo na. This is the situation. Or, my lord, বরের ঘরে পিসি বরের ঘরে মাসি কোণের ঘরে পিসি. Then, my lord, at that time, my lord, a writ petition was filed and that was pending. To cover up that, my lord, to answer to the writ court, my lord, What they did, my lord, the bail cancellation prayer was filed by the interim bail, my lord. That is not confirmed bail. Bail cancellation prayer was made by the police on 15th, my lord. Kindly, my lord, stay, my lord. The 5th, my lord, August 2023, my lord, the interim bail was granted. By this time, my lord, a writ petition was filed, my lord, challenging the process of investigation and also for transferring the, my lord, case in the given situation because of certain circumstances, my lord, to the NIA, my lord.
So police
Then-
filed cancellation of.
Yes, my
When?
lord. State police. I am coming to that. Prayer for bail cancellation prayer was made on 15th September 2023. Your lordships may be kind enough to, my lord, time gap, my lord. On 5th August 2023, interim bail was granted.
On the ground of that,
On the ground, my lord.
on the ground of fraud.
No.
They-
No. That's why, my lord, I will get the privilege. Not
Cancellation was on what ground?
on the ground, my lord. Kindly have a look on the ground, my lord, that some of the persons, my lord, the accused who has been granted bail, who has been released on interim bail, they are threatening, my lord. Kindly have a look at, my lord. I am not reading. I will not waste time, your lordship's time, my lord. What was the ground? Kindly have a look. So, my lord, just to cover up, I have done it. I am covering up. By this time, my lord, since the writ petition has been filed before this honorable court, which is under consideration before this court, they prompted them to save their skin, my lord, to save their actions, my lord, malafide or, my lord, fraudulent action, my lord. What they have done, they had to do it under compulsion. Kindly read this word. By this time, writ petition was filed and court was in session of the matter.
With dire consequences.
Yes. Because police will not file that bail on the ground of fraud because they are the perpetrator of fraud for the purpose of facilitating bail to the, my lord, accused persons.
So you are saying that it has been done. Now you are saying that police did.
No, police, they filed the cancellation bail on a different ground.
If fraud is committed upon any court, then cancellation prayer on the ground of exercising fraud should be
My lord,
made
my
before
lord,
that court.
I am asking this question, who will do, my lord? At that time, we did not have the jurisdiction, or we have not been transferred with the, my lord, case, my lord.
De facto?
My lord,
De facto could have done.
well, that could have been done. That was not aware of this, whether it has been granted bail or not. So, my lord,
Sections were added in charge. De facto brought it to the notice of the, my lord, of this honorable court in the writ proceedings.
and
The court
and
sought for a report from the SDP.
yes,
The SDPO
court was
said,
in session.
I delayed in filing the charge sheet, though it was ready on the earlier day because I was busy with photocopying and pagination of these documents. And when this frivolous report was filed, my lord, the writ court, my lord, transferred the investigation to the NIA.
Was not
With
satisfied.
an observation that because of the facilitation extended by the SDPO of the state agency, the principal accused persons of this case have been enlarged on interim bail. That is, my lord, the backdrop. And my lord, I have shown your lordship that Supreme Court judgment, my lord, Gangi Reddy's case, where in this backdrop, my lord, the statutory bail can also be cancelled. And it is not the case where the bail technically has been cancelled. It is a case where after the interim bail was granted, your lordship knows when an accused is on interim bail, he is obliged to appear before the court. They were not appearing. The court asked their sureties to produce them. When that order was communicated to them, they came and filed an application
To
for
continue on the same bail.
confirmation of
So there was no question of
You
filing
have a chance
cancellation
of
of bail.
giving reply, deal with all those points in
that
reply.
application was heard from time to time. Thereafter, it was rejected. Thereafter, the bail was not confirmed. So, my lord, the state agency did a very interesting thing. My lord, firstly, they facilitated the grant of interim bail. Then when the High Court called for a report that why have you done this, then they quietly went and filed an application just to tell the writ court that, sir, we have preferred an application. They could not have said that because of our misfeasance, the interim bail could be facilitated. That they could not have said that.
Because the state agency was a party to the fraud. My lord. Fraud has been perpetrated by the state agency to protect, my lord, some members of the ruling party in power.
We have understood. Next point.
So, my lord, now, my lord, sections, my lord, now the NIA took up the investigation of the case, my lord. Now, generally, as my learned friend, my lord, what my learned friend,
Investigation when?
my lord, investigation was transferred to, my lord, Milord, that Milord,
By order
the
dated,
Honorable High Court, Milord, was pleased to Milord direct Milord the investigating agency, Milord, NIA, Milord, to Milord on 5th April 2024. Before that, it was filed, Milord. It was court was in session of the matter. Report was being called for, and report was being filed, Milord, by this time, Milord. And ultimately, Milord, that is, Milord, ultimately, Milord, by virtue of the order of the Honorable High Court, Milord, the Honorable Single Bench, Milord, directed the Milord, NIA to take up the investigation, Milord. That was challenged by the Milord State Agency, Milord, before the Honorable Division Bench, Milord. Division Bench, Milord, Honorable Division Bench confirmed the order of the Honorable Single Bench, transferring the investigation to the Milord NIA, Milord. So these are the checkered history, Milord. Under that circumstance, Milord, so NIA registered the case on 16/4/2024.
Production was issued. Production.
Then, Milord, then your learned special code, Milord. Immediately after the, your lordships may kindly, Milord, consider, Milord, there is a provision, Milord, automatic provision, Milord, whenever, Milord, a case is transferred to the from state agency to either to the CBI or to the NIA, Milord, it is incumbent upon the Milord, the persons who are on bail, Milord, they are to, Milord, approach, since it was in interim bail, they are to approach before the transferee court, Milord, new court, Milord. It's a, Milord, general provision, Milord, that they themselves will come before the court, Milord, and they will appear before the court, Milord. But unfortunately, Milord, having some...
No, is this a practice or is it a law, requirement
Yes.
in law?
Requirement law. And that's why, Milord, they did not appear. They did not choose to appear. Then, Milord, what the NIA court did, Milord, where the case was transferred, Milord, on, Milord, 18/4/2024, directed for production of the persons, and surety was directed to explain why they are not being produced, appearing. Under that circumstances, Milord, when the court, Milord, issued the, Milord, order directing the surety to produce the accused persons, Milord, since they were not appearing, even by taking bail, interim bail, in a fraudulent way, they're sitting tight over the matter, they should have come before the court and should have prayed for confirmation of the bail. They didn't do it. Under that circumstance, Milord, NIA court, Milord, directed for production of the, Milord, by 17th, Milord, May 2024, NIA special court directed the surety to produce the accused persons. Under that circumstances, Milord, the learned special court, yes.
When High Court was when High Court directed the transfer, at that time accused represented there.
No,
Your Lordship.
no, no.
None of the appellants
No,
here
no,
were
no.
represented in the writ petition. We were not a party in the writ petition.
How they know?
We were not a party into the writ petition.
They did not intervene in that.
How will they know? They were not notified. This is what they are saying.
Yes, we were not notified by.
Therefore, they didn't.
They have not
Milord,
challenged the order.
Milord,
Only
18
now. The order has again finally. The division bench also
Milord,
has affirmed
18,
that order.
then, Milord,
They didn't move
Milord,
the division bench.
that simple answer is there,
Then
Milord.
we have not been heard.
Simple answer is there, Milord.
Simple question.
Yes, simple answer is there also, Milord. Yes, yes, Milord. Milord, on 18/4/2024, order was issued by the NIA court. NIA court issued, Milord.
When will you come back?
You won't finish 2 minutes left. Less
Yes,
than
Milord.
2 minutes.
NIA, Milord, just my answering this question. Milord, NIA court then, Milord, your lordship was asking me this question, Milord, how they could come to learn, Milord. The NIA court, Milord, then after being transferred, the case being transferred and being taken up, Milord, issued, Milord, notice to the accused persons to appear, Milord. They did not appear. So they have the knowledge that, Milord, since, Milord, if we taken for granted, Milord, they did not have knowledge. But NIA court, Milord, issued the notice asking them to appear. They did not appear. Thereafter, Milord, waiting for some time, Milord, thereafter, Milord, after 1 month, Milord, the notice was issued to the sureties, Milord, for production of the accused persons. So they had sufficient knowledge.
এইটা রাখুন, নোট আছে।
When will you come back?
মিলর
Try to come back as soon as possible to keep a continuity.
Yes, yes,
and,
yes, yes, yes. We are trying to do it as fast as. এই শুক্রবার কি আছে?
আমাদের কবে আছে বলো না, পৌনে একটার সময়?
মানডে মিলর?
Today is Monday.
Monday.
Next Monday.
Yes.
এই সপ্তাহে আমাদের খবর ফাঁকা নেই।
Interesting point.
মানডে না করে না, মানডে করবে না, মানডে তো আবার ওখানে কোর্টে আছে। মানডে কোর্টে আছে, মানে না। Friday মিলর yourself can keep it on Friday.
3:15 fixed আছে।
Friday মিলর। Friday 12:50. Because
ছিল না তো দেখেন।
12:45 আছে কি দেখুন। Thursday দেখি।
Because Friday we need to, huh?
No. Friday আছে।
Very, you want Friday 12:45, right?
12:45.
Whichever date is convenient.
12:45.
Right.
Friday.
I have nothing to.
Mr. Maiti, learned counsel representing NIA, resumes his argument but does not conclude. Paragraph, as requested, let this matter be listed again on Friday date the marked 12:45 p.m.
Deep level.
আগে কি তোমার ইয়ে হচ্ছে দুটো ম্যাটার তো এখন?
Lordship is only hearing
Shall we
one
order?
matter now. CRA 260 is what is being heard by you. CRA 2 DB 260.
হ্যাঁ, CRA 260 তে খালি হচ্ছে, বাকিগুলো সিম্পলি অ্যাডজার্নড হচ্ছে।
সেটা বলছি। ফটোকপি করে কে দিবি?
Item number 1, Jalpaiguri Circuit Bench.
This is not the bench.
We know that.
Don't go. This will take only 1 minute. ওইটা আরেকটা যেটা আছে না কি একটা কেস খালি ডিল করবি জলপাইগুড়ি একটা ব্যাটার আছে ওই ইন্ডিপিএসটা আরেকটা নতুন কেস গুলো পিটিশন গুলো কালকে দুটোর সময় রেখে দেবো 5 মিনিট লাগবে হ্যাঁ এই অন্য যেটা সেই জলপাইগুড়ি ম্যাটার আরেকটা আছে না যেটা হলো না কালকে দুটো কালকে থেকে পরশু রাখবে পরশু 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 করো আছে কেউ We have stayed the impugned portion of the order of the learned single judge, and we have expedited the appeal. The stay application has been disposed of. that a letter has been received by the investigating officer,
Yes. To the officer in charge, Sundarban Coastal.
by the officer in charge, Sundarban Coastal.
Yes. Sundarban Coastal PS.
দেখেছো? কি বললাম না? A letter has been received by such and such from the missing lady. Stop. The state shall conduct due inquiry and find out whether or not the lady is residing at the address from which the letter was posted. Stop. Paragraph as requested, comma, let this matter be listed again on January 20, 2025. Stop. On that date, the state shall file a fresh status report. Stop. The mobile phone that was handed up to her be marked as Exhibit 1 and kept in the record.
My lord, my humble submission, let them produce the letter, my lord, before the honorable court.
Of course, they will. With the report, they will produce.
I have asked my officer whether you register a case for cruelty or not. You go over there, you verify, and you videograph her statement. I have said.
My further humble submission, my lord, they should produce when they have got traced.
Your client used to torture his wife. That is why she has run away.
My lord, they should produce the lady before the honorable court.
Adult lady, my lord, from someone, from somewhere.
My lord,
will satisfy your lordship
my
that
lord,
she is not missing.
My lord, I can show from the my lord case record that
as soon as you demonstrate before us that she is not missing, because still we are not convinced.
Yes.
That is the end of this habeas corpus petition.
Lordship, I am appearing for the petitioner. I am not pressed in this application, my lord.
You are not pressing this application?
Yes, my
মিথ্যে কথা লিখেছিল লিখে নট প্রেস করে দাও
But on the other day, we told your lordship that the girl has already been recovered. And what are they? Report are they? The girl has already been recovered, and we have handed over them the copy. And my lord has asked them whether they want to controvert about the recovery or not.
Yes. What do you say?
Yes, lordship.
Recovered, no?
Recovered.
Then disposed of.
My lord, kindly provide me the address.
Present address.
Whose address? Whose address?
The address of the.
Where is the girl now?
Gopi Vallabhpur.
Where? With whom?
With the person she got married.
I see.
She is an adult lady.
Oh, then?
She has given a statement under 183.
Read order dated December 23, 2024, paragraph. Today, learned advocate for the petitioner says that indeed the missing girl has been traced out. Stop. Paragraph. In that view of the matter, comma. জানি বাবা চাইছে কি ঝামেলা করতে মেয়েটা এসে go and try to talk to your daughter. Obviously, I understand the father is angry or, because she has run away with her boyfriend. Daughter, nothing remains in this writ application for habeas corpus, WP such and such, disposed of. এগুলো accept করবে না অ্যাডাল্ট মেয়েটা করবে না, লুজ ইওর
Name.
For the petition.
Yes.
For the petition. A 12-year-old girl of the petitioner is missing, my lord. Complaint was lodged. FIR was
When did she go missing?
on 19th of August 2020.
24. When did you lodge complaint?
Lord, on 19th, I lodged the missing diary. Thereafter, on 11th 9, I lodged further complaint.
He has filed a report, Mr.
Case was
Who is appearing? You're not appearing?
I do not know.
Have you served?
But service about the private respondent is not completed.
Then serve and come back.
Next week.
Service is not complete. Stop. Let service be effected on all the respondents and affidavit of service be filed in court on the next date. When?
1 week.
Next Monday করে দাও। Relaxation. Are you?
No.
I beg to appear on behalf of the petitioner, Lordship. I have served upon the respondent.
You have served.
Lordship, girl was missing, Lordship, on 22nd of November 2024, Lordship. On the very next day, written complaint was lodged. FIR has been treated, Lordship. The girl is a minor, Lordship. I have annexed the date of birth certificate, Lordship. That will, Lordship, will find from page number 15.
Your daughter?
My daughter, Lordship.
File a report, Mr. Mukherjee.
Yes, then a report. Well, 17 years old girl, my lord, there is a story of love relationship. However, my lord, we have exhausted more or less all process. Publication has been made. My lord, we have taken help of the CID, the Missing Person Bureau. We are hopeful we will be able to trace out. But my lord, there is a story of love relationship, and apart from that, we have arrested the family members of the person with whom we are suspecting that the girl has fled away. But my lord, with no result.
His family members have not been added as parties here.
No. We have arrested to obtain anticipatory bail.
Well, how long do you? We'll give you some time to
20th.
20th. Supply, giving them a copy of the report. The petitioner says that her minor daughter went missing on November 22.
22, Lordship.
2024.
October, Lordship. October 22.
October 22.
October
2024. Stop. Paragraph. The state has filed a report today. Stop. Let the same be kept with the records. Paragraph. From the report, we find that the state has explored several avenues to trace out the girl. Stop. Publications have been made. Stop. The CID has been engaged, has been activated. Activated. Stop. Paragraph learned APP says that the state is very hopeful that it will be able to trace out the 17-year-old girl soon. Stop. There appears to be some romantic reason for the disappearance of the girl. Stop. Paragraph lists this matter once again on January 20, 2025. Stop. On that date, the state shall file a fresh status report.
Grateful to you.
Section 94, Your Lordship, I beg to appear on behalf of the petitioner. This is the evidence of service.
Are there any private respondents?
Private respondent is there. My lord, the case is this, my lord. My daughter is a major, admitted, but her chronological age is more than 18 years, but biological age is like 7 to 8 years. I have medical testimonials I annexed with this. My lord, in the month of June, my lord, missing. Thereafter, I preferred a complaint. police registered a case.
দুজন জজ সাহেবের দুটো।
Police registered a case, my lord. Thereafter, my daughter was recovered. And 164 statement, she said that I did not want to return. And my lord, thereafter, the case was closed. FRT was there. My lord, the thing is this, only one grievance is this. My lord, I am a father, a helpless father, my lord. Till date, I did not even get a single chance to meet with my daughter.
She is the next page.
Now,
she is the next page. What?
No, my lord.
Is the next page.
What I'm
What
praying
is the stumbling block? This is the reason of all dispute.
My lord,
The affidavit.
My lord, my prayer is there is no examination
Affidavit.
of her, my lord, mental assessment on the part of the doctors, my lord. This is my humble prayer before your lordship, that let her mental status should be, my lord, scrutinized by.
She is not missing.
No, initially she was missing when I preferred a complaint.
This is the affidavit of the missing, so-called missing girl.
Yes. There is a feud with regard to religion. She has converted herself into Muslim.
She is not missing. She has given a statement to the magistrate.
Yes, my lord. 164 statement I found it from charge sheet.
Happily living with her husband.
But only thing is this.
What only thing?
Considering her mental aspect, my lord.
Yes, nothing. You are trying to put undue pressure by filing this.
I annexed. This is 2022 report, my lord. Page, my lord, kindly. Only one thing, one prayer, my lord. A helpless father before your lordship, my lord. My lord, only one prayer. My lord, it is my duty, my lord. Page 20, only kindly consider page 20. This is 22 report. In the year 2022, at that point of time, nothing was happened. Thing was happened in the year 2024. I have annexed page 20. Only one.
What? 20?
My lord, page 20.
Yes, what?
My lord, already a psychiatric consultation is there.
That doesn't bring him to juvenility from the age of an adult.
I personally went there. I want to visit with my daughter, my lord.
You want to visit? Who stops you from visiting?
My lord, the private respondents. My lord.
Your document.
Yes, my lord.
You are relying on this document.
My lord.
So this document was in respect of Saranna Adhikari.
My lord, my daughter.
And you took your daughter to the doctor.
My lord.
And what was the advice? What was the advice? Pora Gangawa. And then Mara Bondo. What does it mean? So see your document.
My lord, father, my lord, my lord, my lord.
Who? The parents should love their child. The answer is from your document, sir. Why you are looking at?
Issue, Abhijit. The petitioner says that his daughter went missing in
2024, my lord, 5th June 2024.
Missing on June 5, 2024. Stop. He has lodged complaint with the police. Stop. The same has yielded no result. Stop. Although his daughter is a major, technically speaking, her mental age is that of a 7/8-year-old girl. Stop. Paragraph, learned APP apprises us with supporting documents that the petitioner's daughter is not missing at all. Stop. She is living happily with a person whom she has married. Stop. The statement of the petitioner's daughter recorded under section 164.
183 BNSS.
Sorry. That is 164.
At that time, 164.
No, this is 164. No.
164 was there.
June. It came from July.
164 CRPC has been placed before us. Stop. Let the same be kept with the records. Stop. From the statement, we find that the petitioner's daughter has categorically stated that she voluntarily left the paternal house and married the person with whom she is now residing. and she wants to continue to reside with that person. Stop. Paragraph. In view of the aforesaid, comma, there is no reason to keep this writ petition pending, as it cannot be said that the petitioner's daughter is missing anymore. WPA is disposed of.
Most obliged, your lord.
For the petitioners, my lord. The petitioners were granted bail on 1st of June 2017. Now, my lord, this is the order whereby they were granted bail and certain conditions were imposed.
Why not annexed to your?
My lord, it has been annexed, but I believe, my lord, a copy from indiakanun.com has been annexed. I don't know why. This is the server copy. But I was directed to appear before the learned trial court on every date of hearing and not to leave Kolkata except for attending court proceedings and furnish the address to the officer in charge, Domjur Police Station. Then, my lord, page 12. On 8th of June,
One second.
my lord.
No, my lord, there is no adverse report.
Which one you want to be relaxed? Which condition?
My lord, this is the first. Thereafter, I have moved another application, page 12, wherein I was directed to meet the officer in charge, Domjur, once every week. At page 12. And then, my lord, my third application, page 13, wherein I was directed to meet the officer in charge, Domjur Police Station, once in a fortnight. So this is the only condition it remains. For almost 8 years, my lord, I am complying with all the conditions.
What is the stage?
Possibly the charges are not yet.
Charges have not yet been framed. Yes.
He'll attend all hearings.
Very good. And as and when called for also, my lord, I will attend.
Key charge was the key charge. Murder.
No, my lord. 379, 411, 4.
The petitioners were granted bail by a coordinate bench on June 1, 2017 by an order passed in CRM 4 on June 1, 2017. Stop. One of the conditions, some of the conditions of bail were that the petitioners shall appear before the learned trial court on every date of hearing, they shall not leave the jurisdiction of the city of Calcutta except for attending court proceedings, and shall furnish their place of address to the officer in charge of Domjur Police Station and the learned trial court. Stop. Paragraph. The petitioners moved an application being CRAN 397 of 2018 for relaxation of the conditions of bail. Stop. A coordinate bench modified the condition of bail and directed the petitioners to meet the officer in charge of Domjur PS once in a week until further orders. Stop. Other conditions of bail were, however, directed to continue. The paragraph. A further application being CRAN 2 of 2019 was moved by the petitioners for further relaxation of conditions of bail. Stop. By an order dated February 3, 2021, a coordinate bench directed the petitioner to meet the officer in charge, Domjur Police Station once every fortnight. What about the other conditions?
I will, my lord. I will intimate them where I am staying on every date before the trial court. I will appear.
Paragraph. Now the petitioners have again come before us saying that the requirement of reporting to the officer in charge of Domjur police station may be waived. Stop. Paragraph. Learned state advocate files a report from which we file that the petitioners have been adhering to the bail conditions scrupulously. Paragraph. In that view of the matter, and considering that even charge has not been framed, comma, we are inclined to allow the petitioner's prayer, petitioner's essay for apostrophe. Paragraph. Accordingly, the requirement of the petitioners reporting to the officer in charge of the Domjur police station stands waived. Stop. The other conditions of bail, however, shall remain operative.
I'm grateful, Minister.
And disposed of.
I'm grateful.
Maybe kept in record.
রিপোর্টটা kept in the record. বাবা এইটুকুর জন্য কি ভারী পিটিশন। Charge framed হয়নি।
Habitual offender. 413, 414. You can discuss it.
So,
My lord, 896 and 897 can be taken up together.
In both the matters, you are representing the state.
I am for the state.
896.
896. I am for the state.
1996. My lord, কে দিচ্ছেন? My lord, for once kindly seize the annexure P9, page 37, the last order passed by your lordships only. Well, this petitioner prayed for relaxation to attend a function at Australia, when your lordship's pleasure was to decline the prayer only on the ground that fine right now it is not possible. Now, my lord, he has been granted bail in the year 2022. There was a direction for meeting the officer in charge. My lord, may I take your lordship now once to the first order?
yes.
My lord, may I just it? My lord, kindly comes to page 35. Just the previous order, the annexure P8. That is the order dated 26/7/2022. Page number 35.
Yes, we have seen.
My lord, there.
Once a month, from once a week to
now
once a
I
month.
am only praying since 2022. I am continuing with the compliance of this order. I am only praying.
Waiver,
my lord,
waiver.
Only waiver.
Any adverse report?
There is no adverse report even on the last one.
He is attending the trial.
Everything.
So that he'll continue to do.
1st, 2025. It is for discharge petitioning.
When was bail first granted?
My lord, it was granted in 2022 only.
Which order? Where is that?
10/8/2022.
My lord, it was
17/8/2018.
28. Oh, that is Vishnu Mudra.
17/8/18.
There are no two.
No, not 22. It was granted earlier.
Earlier.
2018.
It was in 2018, page 13.
17/8/2018.
Page 13.
আপনার পেজে
Page 13.
Yes. 10/8/2018.
18.
Allegation against trafficking. Allegation is against you is trafficking.
Allegation against me are here, my lord, under not trafficking. I am a hotel owner. I have restaurants and bar in the city. In this city, I have several. My lord, anyway, after the change of guard in the state of West Bengal, whatever it may be, my lord, it is his counter allegations. There are allegations. My lord, I have been granted bail by this honorable court as well as by Supreme Court. Thereafter, there were conditions which I am complying since 2018. In the meantime, my lord,
I took several applications, my lord, praying for relaxation for medical conditions and sometimes visiting other states for attending ceremonies of my relatives and others. Everything was granted, and my lord, I complied with the orders. This is the only prayer I am making in 2024.
My lord, kindly see page 37. Your lordship's observation, my lord.
সেটা তো অস্ট্রেলিয়া নেই, সেটাই তো প্রথমে মাইলর সেটা তো মাইলর প্রথমেই দেখালাম যে অস্ট্রেলিয়া যেতে না।
The petitioner,
আরে সেটা তো মাইলর
শোনো এই দুটো ম্যাটারই একসঙ্গে নাও। The petitioner was initially granted interim bail on August 10, 2018. Stop. 2018, on certain conditions. Stop. The order of interim bail was confirmed, was extended from time to time, and finally confirmed. Page 25, Mr. Jana, what is the date
page
of the order?
35, 26/7/2022.
Page 25.
Oh, page 25.
What is the date?
My lord, page 25, the date is 10/11/2018.
Yeah. Finally, ultimately confirmed on 20 November 2018. Stop. Thereafter, paragraph 3. From time to time, the petitioner applied for relaxation of conditions of bail. Stop. Such applications were considered favorably by the court. Stop. Paragraph presently, the petitioner says that as per the order dated July 26, 2022, the petitioner was directed to meet the officer in charge of the concerned police station once a month instead of once a week. Stop. He seeks waiver of the said condition. Stop. Paragraph. The state files a report from which it appears that the petitioner has been complying with the conditions of bail. Stop. Paragraph. In that view of the matter, we dispense with the condition of bail requiring the petitioner to report to the officer in charge of the concerned police station once every month. Stop. However, the petitioner shall, any other restriction is there on you? Nothing. Continue to attend each and all hearing before the learned trial court.
I'm grateful.
দুটো ক্রাইম ডিসপোজড অফ হবে, দুটো ম্যাটার আছে না? আচ্ছা, দুটো আলাদা করে দাও, ঠিক আছে।
এখন কি ফিক্সড ম্যাটার হবে? হ্যাঁ, আচ্ছা আচ্ছা, মানে একটা মেনশন করে নট প্রেস করে দিচ্ছি।
তুমি আছো আমার ওয়েল উইশার একটা, তোমার মতন কটা ওয়েল উইশার আছে। কালার চেঞ্জ হয়ে গেল কেন?
My lord, before fixed matter, 181, I'm not pressing this application. I have the
fixed
instruction.
matter?
Yes, 1530.
Oh.
Well, why are the colors of the chairs?
Black is neutral.
Is that black?
181.
Black na to ki? Black na?
No, dark blue.
Anupam Patra.
No. This is black. Pitch black. Yes, 181.
181.
Doesn't want to press it.
Not
Oh,
181.
181. Where is the state? Hey, state.
Let it appear in the list under to be mentioned.
To be mentioned 181 টাকে কালকে to be mentioned করে দাও non-prosecution লিখে।
Deeply obliged.
চলো তার থেকে অরুণদা কি বলে? অরুণদা কতক্ষণ নেবে? অরুণদা কতক্ষণ নেবে?
সময় নেই বলছেন।
আর রিলিজ কি?
কি হলো?
করে দেবে
আলাদা আপনি কতক্ষণ বলবেন দেখুন।
আমার বলার হচ্ছে কি মানে this matter but there is a issue which I was bringing to your lordship's notice. Well, I think the other matters may be released because
Release for the day.
Release for the day. আমি কোনটা কি দেখাচ্ছি এটা?
কিচ্ছু দেখাচ্ছি। আপনি বলতে শুরু করুন না, বলুন।
না বলতে শুরু করার না, দেখো না আমি কি বলছি আগে শোনো না। সারাক্ষণ ঝগড়ার অ্যাটিটিউড কেন? আর তারপরে অনির্বাণ তোমার পাশে আর বাঁচতে দেবে তুমি?
Mr. Maiti is.
Well, sees the order of 16th of July.
Yes, that's the last order on record.
On record. So, my lord, I had finished, but 6 months have elapsed. Should I take that now, repeat it, or after the reply of Mr. Maiti? 6 months, my lord, have passed.
আপনি বলুন, বলে দিন, তারপর সুবিধা হবে আমার কবে।
আমিও লিখছিলাম।
6 মাস আগে কি বলা হয়েছে তার কি মানে ইয়ে আছে?
Well, your lordship, I think Justice Srinoy has made notes. Acha.
Let Mr. Maiti continue, Mr. Mukherjee, because we'll request you both, since it's being argued at some length, to at the end of the hearing to file very short notes.
Yes, in each and every cases we are doing.
We are doing that. We are doing that. Just to recollect, Mala. It's a question of recollection of what I had said.
Issue of sanction by DM.
Yes, that's the thing. I'll let him answer, Mala. But before I go, Mala, I'll tell Lordship what happened. Mala, 5 persons are on bail. 5 persons.
7 accused, 1 died.
1 died. Right. And 7th is me. 5 on
one
bail.
was injured.
1 died, and 1 is the present petitioner before your lordship. But one thing which has been troubling me, which my lord may ask my learned friend, is, my lord, in the charge sheet which they filed, the NIA, they said that we are not discharging anybody from this case because we are still investigating the role of these petitioners. My lord. So, my lord, why I'm trying to bring it to your lordship notice is whether they have completed it after 16th of July 24. Well, just see the charge sheet, paragraph 12. Well, incident is of January 22. NIA took it in September 22. Within that period, well, those who were arrested were granted bail by the Chief Judicial Magistrate. My information, subject to corrections by my learned friends, are, well, in respect of the persons who were granted bail in 22, April and May 2022, but the NIA has filed an application for cancellation in the month of January 2024. That's subject to correction by my learned friend. But that is still going on. That has never ended as yet. So I want to make it your lordship noted prior to them saying it. So whether your lordship will hear me on merits again or not. Which I think, I stand on a different footing altogether. Because I'm before your lordship. So, my Lord Justice, your lordship will see paragraph 12.
Kindly just recapitulate, then briefly recapitulate.
Yes. Malat, there was a bomb being done. One, it blasted. It was rocket bombs. It blasted. It blasted, caused the death of one person. And after that happened, Malat, after September 2022, NIA took over investigation. NIA, when it took over investigation, it relied on 5 protected witnesses. And my lord had directed them to supply me a copy of these witnesses who have been named. My lord, I wouldn't use the word named, but whose statements were recorded being protected witnesses. Now, my lord, I had told your lordship only after your lordship insisted that it was given over to me. Now, my lord, if your lordship would please seize the 161 statements of those protected witnesses. And whether your lordship can understand the head or tail of these statements. Now, next page.
Section 17.
Blanked out. I can appreciate the name and everything, but it's বার করে না বলবো কি তুমি শনিবার পাশে থাকলে আমি কিছু বলতে পারি
বলুন বলুন
আমি আজ অব্দি কোনোদিন জিতিনি ওরে গেছি আমার 42 বছর প্র্যাকটিস
গেছি বলুন ম্যারেজ করুন এক বছরের সিনিয়র আপনার ফেভারে হলো
হ্যাঁ
আপনার ফেভারে হলো
গানের কথা
এটা এক বছরের সিনিয়র বাড়ে
ওটা আমার ক্যালিবারের জন্য না স্যার তারের জন্য বাবা মার আশীর্বাদ দিচ্ছে
ঘুম বাঁধার কাজ হচ্ছে একটা কাজ আর কি একটা পুলিশ একটা
Yes. Your Lordship has gone through it. Now, please seize the charge sheets, where the roles of the persons pertaining to 6 persons, well, including myself, has been highlighted by the NIA. Para 18. My Lord will pardon my handwriting there. Para 18. Hey, we would have put যাতা করছে
You are A3.
Main conspirator A1.
Imdadul Haq is on bail.
Yes. All are on bail excepting me. I'm in custody since 16th of June 23.
That is perhaps prior to investigation was taken over the investigation of the case, not before that, Milord.
Co-conspirator.
All are co-conspirators. And
So
he's the
that is, Milord, my learned friend is pointing out, Milord, subject to what your lordships may, Milord, consider. Milord, that was prior to, Milord, taking over investigation by the, Milord, NIA, Milord. And this power was exercised by the central government itself, Milord, suo moto, under section 6, subsection 5 of the, Milord, NIA Act. Considering the gravity of the offences and, Milord, the situation, central government itself took up the directed the NIA.
That case you are.
No, I will submit all the documents, relevant documents, Milord, to show the complicity of.
There, Imadul Haq is the main conspirator, and Mansoor Ali
Yes.
is the co-conspirator.
Yes.
So main conspirator has been.
Milord, what I am submitting, kindly, Milord, consider. This was, Milord, the cancellation of bail was filed, Milord, by the NIA, Milord, when the UAP Act was not incorporated. And police, when the police filed the charge sheet, Milord, thereafter, Milord, at that time, Milord,
Whether Mansoor Ali is a main conspirator or not?
Milord, both are, Milord, conspirators.
Your document.
Co-conspirator, Milord, linkage is there, Milord.
So they are main conspirator.
Yes, linkages are there. I will show. Milord, I will show, Milord, because considering that Beldanga's gravity of the offences, Milord.
Mr. Maitri, you have not completed your argument. We have interrupted. We asked Mr. Mukherjee to recapitulate.
Yes, yes.
Let him recapitulate.
Yes. So, my lord, those were the things. So, what happened, my lord, when it comes to an explosive act, substances case, my lord, NIA has the authority to take over investigation. There's no second opinion on that. What I am on is, my lord, there is a provision for sanction in respect of the Explosive Substance Act.
Yes.
I told you, lordship. Now, my lord, may I have this? Sahib, ekটু দাও না ওইটা চার্জশিটটা বস না কেন ফোন নিয়ে খেলছিস সিরিয়াস ম্যাটার চলছে এটা একটু মাই লর্ড জাস্টিস সিনহা রয়কে দিই My first 4 lines, your lordship will please see.
Recommended by the Superintendent of Police.
Yes. And then, man, read it, please. Against whom is the sanction being given, man? The sanction is being given by 3 persons here. The DM, the ADM, and the arms expert. What you see on the next page.
Yes.
Right, Bharat? See the concluding part. Sanction is accorded under 345
Explosive substance.
against FIR named accused persons. Malad, please, and now I give the FIR, Malad, of NIA. My lord, what little knowledge I have of sanction.
FIR. This is FIR.
Yes. Sees the names there. My lord, what little I have learned of sanction is sought for after culmination of investigation. A prerequisite before taking cognizance of the offense. That's the basic principle of sanction. Now, when we come to the basic principle of sanction, sanction requires independent thinking of the person who has been given authority under the law to apply his own mind, not to be swayed by the report of the SP or the investigating agency. That's the basic thing we've learned, and Supreme Court judgments, if your lordship wants, I can give it to your lordship. So the question here is, my lord, the sanction is being given against the FIR named accused persons. Number one. Number two, the sanction which has been given consists of a section for which cognizance has not been taken. So whether there was application of mind or non-application of mind. Now, my lord, if your lordship sees the first four lines of the sanction order by the DM. Lordship will see there, it is on the request of the SP. As per the prayer of the SP. What is the way how a sanction is to be accorded? All the documents which have been recovered, which has been seized during course of investigation, those has to be placed before the sanctioning authority. Now, the sanctioning authority, if they find that this is a sanction where this should not be there, this should be there, then the court can only take cognizance of what the sanctioning authority says. Against that, my lord, a very interesting thing here is, my lord, three persons, the DM, the ADM, and the arms expert are giving sanction. But if your lordship sees the section speaks about the appropriate authority, not the appropriate authorities. And an armed expert does not apply his mind. It will be deemed, if your lordship sees it, that these three persons had applied their mind individually. I'm saying, well, independently, and granted sanction. That is not there in the sanction order. But I have not come for quashing of the proceedings. I have come before your lordship for bail on the parametria saying that I stand on the same footing as those persons who have been granted bail in April 2022. I was taken into custody on the 16th of June 2023. I'm in custody since then.
আমারটা কোথায় গেল আবার? আমারটা কোথায় গেল? Explosive substance.
Explosive Substance Act.
Yes, my lord. No, my lord, that is, my lord, National Investigation Agency Act passed.
NIA Act, my lord.
NIA Act, my lord. I have given it.
Oh,
I hand it over to your lordship.
NIA Act we have.
But I just gave it to you, Lord.
But I have given it to your lordship, my lord.
পাতলা বই। তোমাকে সেকেন্ড কপি নেই।
হুম।
তো দিয়ে দাও। আমি দিয়েছি
আচ্ছা,
একটা।
দিচ্ছি দেখো।
আমি একটা দিয়েছি।
ব্যাগটা আছে? হ্যাঁ? বাস করে নিয়ে এগুলো কোথায়? দে 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 দে। নিয়ে নে। ভাস্করও নেই, এও নেই।
এটা কি এই
এখানে আরেকটা
পাতলা কি পাতলা দিয়ে করবে একদম পাতলা করেছে
ডিস্টার্ব করিস না।
ইউজলেস বই। হ্যাঁ, নিচে একটা আছে দেখো তো।
ভাস্কর আসেনি, ভাস্করের ইয়েও নেই, বইও নেই।
তার ভেতরে NIA নেই।
আমার বইটা আছে।
একদম ধারে যে পাতলা ওটা না। না, পাতলা থাকলে আরো আছে পাতলা। ওই ডান দিকে আরো ডান দিকে যাও।
এই তো একটা বই আনবে
না,
তাকে না জানে
আরো ডান দিকে কোডের CPC পাশে।
বলে দাও কাউকে একটা।
হ্যাঁ,
এটা
এটা
বলে দাও, নিয়ে চলে আসবে। চলে গেছে।
কন্টেম্পট ডাউরি
নেই,
তুই একটা কাজ করতে, তুই
এই
আমাকে
তো আনিয়ে রাখবে।
যেটা বের করতে।
Give one copy.
বলো মাই লর্ডে আছে।
আছে ওখানে। রে কোথায় এটা দিচ্ছিস তুই?
Number 6 তো?
এটাকে আরে এটা কি করছিস তুই? ন্যাশনাল ইনভেস্টিগেশন এজেন্সি একটা বের করছিস। এটা ন্যাশনাল ইনভেস্টিগেশন কোথায়? এটা তো এক্সক্লুসিভ সাবস্টেন্স অ্যাক্ট। করিস না তো। ভাস্কর আসেনি, একটা বইও আনেনি, পাঠায়নি। আমারটা দিয়ে দিলাম। So, my lord, kindly, my lord, have a look that the provisions of section 6, subsection 1. On receipt of an information, my lord, when there is a schedule offense, my lord, under section 2F, 1F of the, my lord, National Investigation Agency Act, my lord. Because, my lord, on receipt of information recording thereof, under section 154 of the code relating to any schedule offense, the officer in charge of the police station shall forward the report to the state government forthwith. So, my lord, the police officers who took up the investigation, suo moto, my lord, had the informations. And second is, my lord, the provision of subsection 1, my lord, demands that immediately after the information is received by the, my lord, in recording the FIR under section 154, it must intimate it to the, my lord, officer in charge, to the state government. Then, my lord, comes, my lord, 2. On receipt of report by under subsection 1, the state government shall forward the report to the central government as expeditiously as possible. So, my lord, second provision is, my lord, provision, my lord, subclause 2, my lord, subsection 2, that if that information is forwarded by the officer in charge to the state government, then immediately on receipt of information, state government should forward the report to the central government. Then, my lord, provision, my lord, subsection 3, my lord, on receipt of the report from the state government, the central government shall determine on the basis of information made available by the state government or received from other sources. My lord, kindly I am emphasizing that on other sources. Within 15 days from the date of receipt of the report, whether the offense is a scheduled offense or not, my lord, and also whether, having regard to the gravity of the offense and other relevant factors, it is a fit case to be investigated by the agency. So, my lord, third, my lord, subsection 6(3), my lord, it gives a, my lord, authority or opportunity to the central government to scrutinize if it is forwarded by the state government to the central government so far as occurrence of scheduled offense is concerned. Then, my lord, subsection 4 is, my lord, to formation opinion by the central government. Where the central government is of the opinion that the offense is a scheduled offense and it is a fit case to be investigated by the agency, it shall direct the agency to investigate the said offense. So, 1 to 4, 1 to be forwarded by the officer in charge to the state government, then 2, state government will forward it to the central government, and 3, scrutiny will be made by the central government, and 4th, subsection 4, the central government will form an opinion. Then comes, next provision, that is what I was submitting before your lordship. 5. Kindly have a look at 5, here your lordship has seen, peruse that on the basis of information made available by the state government or received from other sources, I'm emphasizing on the words other sources. Now, come to section 5, subsection 5. Notwithstanding anything contained in this section, if the central government is the opinion that a scheduled offense has been committed, which is required to be investigated under this act, it may suo moto direct the agency to investigate the said offenses. Here, the state agency officer in charge of the police station, did not inform it to the police station, to the state government. State government did not forward it to the central government, and central government did not have the opportunity to scrutinize whether it is scheduled offense has been committed or not. 4th, their opinion could not be formed. But that was a clause, I was submitting, that from other sources, whatever may be the sources, it was gathered by the central government, considering that the Beldanga case, that is a gravity of the offenses and the situation, the central government, in exercise of the power under the provisions of section 6, subsection 5, suo moto took up the source report and direct the agency to investigate the case.
Mr. Maiti, nobody is questioning the power. Nobody is questioning. Need not justify.
No, power is, why I am submitting, because only to demonstrate, gravity of the offenses, My learned friend was submitting before your lordships, that socket bomb. It is not socket bomb. It is iron socket bomb. Chemistry report and FSL report will prove that these are not the ordinary bombs. Iron socket bombs and socket bombs are two different compositions of the bombs making of infectious bomb are also different, having devastating effect of the bombs, and also 105 crude bombs, that is, iron socket bombs were recovered. First, police recovered 75. Thereafter, after that, in phases, what total bombs, socket bombs, iron socket bombs, or 105 was recovered. Perhaps, I was submitting before this, because of the reason, considering the gravity of the offenses, and the one person died, and another person was injured, central government suo moto exercised the power under the provisions of section 6, subsection 5. And with what police did, what was the section incorporated, kindly have a look. Police referred to. Police referred to bill. Police referred to. Police referred to. Now kindly have a look at Miller. আরেকটা কপি আছে, দুটো কপি আছে তো? তিনটা আছে তো? আচ্ছা, চার্জ sheet. Kindly have a look at the charge sheet.
এটা দাও। দাও।
That is, FIR number 26 so and so, 17/1/2022, suo moto FIR. Who are the accused persons, This Mansoor Ali before your lordship, in the suo moto FIR, he is an accused person. Can you have a look at accused number 4? Hmm.
Mansoori is accused 3.
A list of FIRs.
Accused 3.
Yes, accused number 3. So, my lord, he is an accused number 3. My learned friend was submitting, my lord, before coming into the merits of the case, my lord, that, my lord, so far as a sanction order is concerned. Sanction order. Sanction order.
Mr. Maiti, we just satisfy us on one point.
Yes.
Whichever court, whichever tribunal, whichever agency rightly, wrongly granted bail to 5 out of 6 accused persons, the bail order is still operational. You have filed cancellation in January 2024. Till date, you have not succeeded in getting the bail cancelled. Why should we not, solely on the ground of parity, noting that your own charge sheet,
no, my lord, there,
if you don't allow us to complete, we will not be able to respond.
My lord, my lord.
On your own statement, you have said the main conspirator is, where I look in
A1.
Imadul Haq, and the others are co-conspirators. So when the main conspirator is on bail, rightly or wrongly, according to you, the main conspirator, not according to anybody else, then why should we not also grant that privilege to, subject to, if you get the bail of the other persons cancelled,
my lord, kindly.
This chap's bail will also go?
No. Kindly, my lord,
No,
my lord, kindly have a look at the order sheet, my lord. Kindly have a look at the order sheet. On repeated occasions, my lord, they are taking time. And that apart, my lord, first of all, my lord, when they were granted bail, my lord, UAP Act was not added.
43D.
Yes. Section 43 D5.
Bail can't be granted.
Yes, my lord, like NDPS Act, my lord. My lord, there is, my lord, that is stringent sections is there. My lord, so, my lord, my humble reply to your lordship's query would be, my lord, first, my lord, before coming into the merits of the case and the materials collected during investigation, my lord, that the bail which was granted during the investigation of the, my lord, the police agency, my lord, state agency, my lord, those who were granted bail at that time, UAP Act Section 18 was not added, was not incorporated. So, whenever, my lord, graver section is added, my lord, then, my lord, it is the provision, my lord, that the previous bail which was granted, he has to take bail afresh or to allow make application for continuing on the same bail, because it cannot continue on the same bail.
So have those accused persons done that?
No.
Then how are they enjoying bail till date?
That is the thing, my lord, in the process, they are taking time after time. I have given the order sheet, I will collect all the order sheet and give it to your lordship, my lord. This is the thing, my lord. That was, my lord, what was the sections, my lord? Kindly see when the bail was granted, my lord.
Very well, you continue in your own way. Sorry,
yes,
we will not interrupt.
No, my lord. Kindly, my lord, that, my lord, when your lordships are asked this question, my lord, it is my humble duty to assist your lordships. My lord, because of the reason, my lord, when the police submitted the charge sheet, my lord, and I will refer to the Pradeep Ram's case, my lord, even after framing of the charges, if the UAP Act is added, my lord, then in that case, my lord, even if the charge has been framed, or the charge sheet or the charge had been framed at this stage, if the investigating agency, that is NIA case, my lord, it was decided by the Honorable Supreme Court.
How long is he in custody?
My lord,
16 June 23.
16 June 2023. And
1.5 years.
Yes.
Trial has started.
My lord, the copies have been supplied. Only because of this reason, my lord, that cancellation of
witnesses are there. Charge film 9 has copy supplied.
And next date of final hearing of this cancellation of bail application is, my lord, fixed on
cancellation of bail for the time being.
101 witness.
110 witnesses.
No.
And charge has not yet been framed.
No. And that I showed you, lordship, paragraph 12, whether they are still continuing with the investigation in respect of those persons.
ইনভেস্টিগেশন কন্টিনিউ করছেন আপনাদের ইনভেস্টিগেশন কন্টিনিউ করছেন না
110 কোথায় পেয়েছি? Sorry, 110, right? 101. Well, it's 101.
101
101.
Is we are looking at the Article 21 angle.
Well, this is in respect of
no article 21 perhaps my lord
grant
for applying article 21 my lord
Telling my brother.
my lord he,
They are taking time to give reply. Prosecution has come.
And the next paragraph, your lordship's role, High Court's role.
Anyway, let us hear him.
Yes, yes.
so my lord
Oh.
now your lordship may kindly consider I will also argue on that point my lord that my lord the when the bail was granted and all were granted bail my lord when the state agency my lord were investigating the case after the investigation was taken over by the my lord NIA my lord then my lord the UAP Act was added. So then my lord the provisions of Unlawful Activities Act my lord section 40D3 will be applicable. And I will also refer to my lord one judgment of the Honorable Supreme Court and other judgments also are there my lord that my lord in that case my lord that even if my lord when a new section a graver section is added that is UAP Act is the graver sections which my lord postulates my lord the section 15 of the Unlawful Activities Act here. What is that section 15 my lord? Section 15 your lordship has got it my lord. Another yes, we got it, my lord. Now, my lord, UAP Act, my lord, Unlawful Activities Act, my lord, that is when re-registration of the FIR was made, and my lord, UAP Act was added, and charge sheet was filed under the provisions of UAP Act also, section 18. Now, my lord, to attract the provisions of 16 or 18, my lord, or 16A, 18, my lord, what is the definitions, my lord? Section 15 of the UAP Act. Whoever does any act with intent to threaten or likely to threaten the unity, integrity, security, economic security, or sovereignty of India, or with intent to strike terror, or not and my lord. It is not my lord, it is disjunctive, my lord. That is with intent to strike terror or likely to strike terror in the people or any section of the people. Not only, my lord, for the purpose of threatening the sovereignty of the country, but, my lord, any part or any people likely to strike terror in the people or any section of the people in India. In India includes also, my lord, state of West Bengal. State of West Bengal includes any part of the state or in any foreign country by using bombs. Here, my lord, your lordship, my lord, kindly, my lord, see, my lord, that, my lord, iron socket bombs, my lord, I will come to the composition of iron socket bombs and the devastating effect of that, my lord, composition will, my lord, speak. The gravity and also.
When you have submitted charge sheet?
Your charge sheet was for, submitted on, my lord.
12/12/23.
12.
Commencement of trial was not done.
Copies have been supplied only, my lord. Hearing of the application for cancellation is being carried on, and they are taking time after time to drag the proceeding.
Cancellation of bail is for
Yes, my lord.
your side.
Yes,
Yes,
but they are taking time. They are for filing reply. They are for giving the reply, for arguing the case, and the order sheet reflects that they are delaying the process so that the trial may not be commenced. So the trial may not be commenced.
Why cannot trial commence without first finally disposing of the cancellation?
Interlocutory application, when it is not disposed of, my lord, finality cannot be reached, my lord. Final, my lord, charge cannot be
Which law says so, Mr. Maiti?
Lord, in every matter, my lord, keeping the interlocutory matter pending, my lord, both in civil and criminal, my lord,
Very well.
the main matter cannot be disposed of. But so far as the cancellation is concerned, we are not dragging the proceeding. Or repeated order sheets will show that they are dragging the proceeding. They are not allowing the trial to proceed. So that cannot be attributed to us. If your lordship passes an order, then on 8th it will be finished. We'll immediately after we'll go for framing of the charges. And so far witnesses are concerned, unlike other agencies, we always minimizes the witnesses. Not that 101 will wait for 101 witnesses. This is not the procedure we are not adopting, at least the NIA agencies. NIA.
At the time of considering the bail prayer, Honorable Supreme Court is considering the number of witnesses also.
Yes, where number of witnesses also.
101.
Yes, number of witnesses here, when the trial commences, if the trial commences and we propose to examine all the witnesses and the length of time to be calculated for the purpose of examining witnesses, that point comes. Now, if we cannot start the trial, we cannot assure. If we are allowed to continue the trial, start the trial, we can assure your lordships, that we'll continue it within 1 year or within 8 months, or we can do that. A day-to-day basis, trial we are holding in trial courts. So kindly have a look at that cannot be a ground for granting bail. When there is no delay cannot be attributed on our part that we are delaying the matter or we are seeking for adjournment of hearing of any matter. We have done it. We have supplied the copies immediately after the charge sheet were filed, by using bombs, dynamite, or other explosive substances, or inflammable substances, or firearms, or other lethal weapons, or poisonous, or so and so, likely to, numbered by any other means, whatever nature to cause or likely to cause. So, section 15 contemplates likely to cause or likely to cause. Here, one person died and one person was injured. So, death was caused. Now, here, bombs were used, terrorize the people of the area, devastating effect of which, one person died, one person were injured. 100 iron socket bombs, crackers, and iron socket bombs. These are different with different footings and different components also. Composition of the bombs are also different explosive substances. Now, section 18 we have added. Section 18 of the UFE Act, whoever conspires, kindly mark the word, whether main conspirator or conspirator, whoever conspires or attempts to commit or advocates, abets, section 18, I am reading. Lordship has got it. Punishment for conspiracy, it is whoever conspires or attempts to commit or advocates, abets, advises, or by the amendment is incorporated, incites, directs, or knowingly facilitate the commission of a terrorist act. Terrorist act has been defined under the provisions of section 15, subsection 1. Terrorist gang or terrorist organization. Here, not organization, gang. For the purpose not specifically covered under section 15 shall also be construed as an offense. Punishment for conspiracy. Kindly have a look. Next paragraph 18, that is, whoever organizes or causes to be organized any camp or camps for imparting training or social terrorism. So, section 18, conspiracy, not less than, we shall not be less than 5 years, but it may extend to imprisonment for life. Here, your lordships may kindly remember that, one person died. It is not an accident. It cannot be in an accidental thing. It was a deliberate act for the purpose, attempt for the purpose of terrorizing the people under the provisions of section 15. It comes within the definition of terrorist act. Not a firecracker that somebody was preparing, having no knowledge, it bursts there was a blast and people died, but that is a different thing. But here, deliberately, abatement was there, conspiracy was there, preparation was there, and ultimately bombs were prepared and bombs were used. So this, my lord, attracts the provisions of section 15 within the definition of section 15 Terrorist Act under the UAP Act, Unlawful Activities Act, and the provisions of section 18 we have added, my lord, that is there, my lord. So, my lord, this is not a, my lord, simpliciter case where, my lord, that a police submitted the, my lord, carried on the investigation and submitted the charge sheet, my lord, under the provisions started when the case was started, under the provisions of section 120B, 334, 324, 326, 307, 34, and 3, 4, and 5 of the Explosive Substances Act. And also kindly have a look at, my lord, the Explosive Substances Act 3, 4, and 5. Thereafter, I will come into the merits of the case. Explosive Substance Act there. Explosive Substance Act there. তুমি চলে আসো, তুমি বই আনবে না, ভাস্কর আসলো না, বইগুলো আনবে না, আমি সব নিয়ে আসবো। কিন্তু বইটা আমাদের ব্যাগে তো ছিল। বাইরের জিনিস, জিনিসগুলো না খুব ভালো জিনিস। এগুলো সাবস্টেন্স একটা দে, এগুলো সাবস্টেন্স একটা দে না। এতে মোবাইল থেকে বের কর না। এক্সক্লুসিভ সাবস্টেন্স একটা বের কর। তোমরা কিছু আনবেন, সব আমার উপর নির্ভর করবে। Lord, Explosive Substances Act, my lord. Punishment for causing explosion likely to endanger life or property, likely to endanger. Section 3 of the, my lord, Explosive Substance Act. Punishment for causing explosion likely to endanger life or property of any person who unlawfully and maliciously causes by any explosive substance, here, my lord, iron socket bombs, and explosion of an injury to person. Here, my lord, one person was injured, another person died, my lord. Or property has been actually caused or not. But section 3 also, my lord, contemplates, my lord, even if, my lord, no injury is caused, if no person dies, my lord, or no property is damaged, my lord, in that case, even, my lord, that section, provisions of section 3 of the Explosive Substances applies, my lord.
This is done at the time of preparation of explosive.
Yes, yes, yes.
But it is not hurled to anybody. That explosion was not there.
No, place was, my lord, kindly have your
Preparation of explosive.
your lordship has to, your lordship has to, your lordship, you kindly, my lord, your lordship may, yes, your lordship may be kind enough to, my lord, consider, your lordship consider the place, my lord, that near Beldanger School, very near to Beldanger School, nearing to the adjacent Beldanger School.
Diary. Diary.
Beldanger School, nearing the Beldanger School.
ঠিক আছে, ঠিক আছে, চলো diary.
Fortunately, school was closed.
তুমি মালিক, আমি কোথায়? অনির্বাণ পাশে আমার সাথে কথা বললে যদি আয়োগ পেয়ে যায়, ওই জন্য কথাই বলছে না।
সেই ঘরে সব অরুণদা তৈরি করে আসবে, ও চুপচাপ
জানো না, ও ভয়ে কথা বলছে না যদি আয়োগ কিছু বলে।
ইয়েতে শুক্রবার দিন একটা
ভাগ স্যাম্পল সব তোমাদের এনেছো।
না, শুক্রবার যদি হয়, শুক্রবার দিন কিন্তু একটা পিক্স আপ অলরেডি একটা হয়েছে 12:45-এ। দেখি সোমবার দিন করবেন, সোমবার করলে পৌনে 4টে, পৌনে 4টে, পৌনে 4টে, কেন সোমবার দিন একটা এনআইএম এগুলো সব নিয়ে আসবে সব। আমি একটা করে বই, আমি এতগুলো করে বই কিনে দিয়েছি, কেউ আনবে না, কিছু করবে না।
Uh, 3:30 Thursday.
Not that we know of. I mean,
No, not that. Your Lordship fixing at 3:30 on Thursday. Friday there is a 3:30.
there is
There will be. There's one in stock.
Thursday.
Thursday.
Yeah, 3:30.
Mr. Maiti, learned counsel representing NIA resumes his argument but does not conclude. Paragraph lists the matter once again on Thursday, date the mark
9th
3:30 p.m. 9. Mark
3:30.
3:30. Hey, Nino, 5.
হ্যাঁ এই মোবাইলটা কে নিল ওর এখান থেকে? দাও।